Good day, class, and welcome to CRJ 105, Introduction to Criminal Justice. I am Professor Darrell Ouellette, and welcome to this online lecture. Each lecture in this course will correspond with the outline that each of you should have looked at, the outline in your syllabus. In this first lecture, I would like to give you an overview of the entire United States criminal justice system. The criminal justice system means different things to different people. Some people would say that criminal justice involves police going out and arresting people. Others will think of criminal justice as the court system. Others will think of it as the laws that have been passed and laws that you need to follow. Actually, it's all those things and much more. In this slide, I've drawn for you what I call a criminal justice funnel. If you think of the criminal justice system as a process, you can think of it as things being poured into a funnel, and as you drain down the funnel, you come to an end or a resolution. In the criminal justice funnel, the system actually starts with crimes being committed. Crimes are committed every day by different types of people for many different reasons. Not all crimes are reported, but once they are reported, then law enforcement gets involved and the crime is then investigated. Not all crimes get reported simply because not all crimes are discovered. You may go outside one day and see your mailbox laying on the side of the road. Some people would think that possibly the wind blew the mailbox off its post. Others may think that someone committed vandalism to their mailbox. Some teenager may have ripped the mailbox and thrown it down. May have even damaged it. So some citizens would pick up the phone and call the police to report it. Some citizens may think that maybe they don't want to do that. They don't want to waste their time. Others may not know if a crime has been committed or not. So even though a crime is committed, some get reported, some don't. When they get reported, sometimes the crime gets investigated, or at least most of the time it gets investigated. In cases where you have a minor violation, like a mailbox that's been taken off its post, the police may not spend much time investigating that. What drives police is that, if they have the resources to investigate, they will. If they're limited as far as number of law enforcement available or the time that it takes to investigate a minor crime, they may not open up an investigation. So some crimes are investigated, others may not be. If an investigation is open, the police may find a suspect or suspects, and they may charge that suspect with the crime. You notice as the funnel gets, as you go through each process, the funnel narrows. There are much more crimes committed than there are reported. There are more crimes being investigated than actual suspects being arrested. And if a suspect is arrested, then you have court action. The person is charged with a crime, and the suspect, needs to appear before a judge in a legal proceeding. If the person pleads guilty or a trial occurs and the person is found guilty, then a judge will sentence that person to a fine or possible prison. The corrections part of the funnel is the actual punishment part of the criminal justice system, where a person goes to jail or to prison. Again, as each step occurs, the funnel gets narrower until there's a resolution to the crime, and at that point, once the resolution has occurred and been taken care of, then the person is returned to society and hopefully will not reoffend and will join society as a law-abiding citizen. Okay, let's quickly review what I just said. The beginning of the process, the top of the funnel, a crime is committed. The crime may be committed, but if it goes undetected, it may not get reported. Or the person who discovers the crime, the complainant, may choose not to report the crime. If the crime is reported, police will get involved. Most often, the police will investigate the crime unless it's a very simple crime where the loss of the property is not great, or there are no witnesses and there's nothing to do with the crime itself as far as an investigation. There may not be any witnesses, there may not be any physical evidence to connect the crime to anybody. But most crimes are investigated, especially the more serious crimes. An investigation takes place. Police will do interviews. They will gather physical evidence. They will possibly, that evidence will take them to a suspect. Once the police have probable cause to arrest a suspect or charge a suspect, that person will then be taken to court or will be summoned to court. The court action, again, the suspect has the right to plead guilty or not guilty. They have a right to an attorney, and they have a right to request a trial and defend themselves. If the person is found guilty, the process continues. The judge will sentence the person to either a fine or some sort of a jail sentence. Once in jail, we call this the correctional process. The person will serve his time, and once out of jail, he may also have to be on probation for a while and answer to a probation officer. The United States Constitution is the foundation of our criminal justice system as we know it today. Our forefathers wrote the Constitution in the 18th century. The Constitution contains amendments which have a direct influence on how each individual in the United States is treated within the criminal justice system. There are many amendments to the Constitution. Certainly some are more important than others in dealing with our criminal justice system. The first 10 amendments of the Constitution are known as our Bill of Rights. Some of the more important amendments within our Constitution will be mentioned many times throughout this course. And they are the First Amendment, the Fourth Amendment, the Fifth, Sixth, Eighth, 13th, and 14th. I will briefly describe each of those amendments in this lecture. The First Amendment allows freedom of the press, freedom of speech, freedom of religion, and the right to assemble. Most people would view this as probably the most important amendment because it spells out our freedoms within the United States. Even though we have freedom of speech, it doesn't mean that we can just step out and say anything. We are allowed to speak our own minds. We're allowed to say, give our opinions on most topics. We have a right to assemble and demonstrate. But freedom of speech is sometimes limited if you are breaking the law by speaking. You're not allowed to mention the word terrorists or bomb on a plane in today's society. You'll be taken off the plane because you'll be suspected of being a terrorist. You cannot yell fire in a movie theater and cause a stampede. These are things that go against our safety, and you could be charged with criminal threatening, terrorizing. So we are somewhat limited, but generally most Americans have the freedom to speak out and say whatever they want, as long as they're not violating any laws in doing so. The Fourth Amendment prevents unreasonable searches of our homes and personal property. That was put in simply because our roots are from Europe. Most Americans came over from England. They were joined later by immigrants from other countries. In the early years, before the United States was settled, soldiers would search people's homes for no apparent reason. Once we settled in the United States, our forefathers wanted to write a constitution and put in the Constitution that unreasonable searches of our homes and personal property would not be illegal. Soldiers could not step foot on your property, and later on police, as law enforcement came into the picture, they could not just simply go into your house and search your homes. So that was put in for that reason. In today's day and age, searches do take place in people's homes by police only if police have probable cause to believe that a crime has been committed and evidence is contained within your home or personal property. And in order to do a legal search, police today either need a search warrant or they need permission from the owner of the property to search. We call that a consent search. The Fifth Amendment is the double jeopardy rule. It states that a person cannot be made to be a witness against themselves. That's the self-incrimination amendment. We hear this all the time where someone will say, I plead the fifth. We hear it quite often. We also see it quite often in the movies. When someone says they plead the fifth, they're saying that they're not going to make a statement to incriminate themselves. Anyone who's been charged with a crime is not required to take the stand to testify. It is the responsibility of the state to charge someone with a crime, and it is also the responsibility of the state or the government to prove that a person committed that crime beyond a reasonable doubt. Just because you've been charged with a crime, it's not your job to prove your innocence. It's more the responsibility of the state to prove that you are guilty. And therefore, unless they can prove you're guilty, you have the option of taking the witness stand to defend yourself, or plead the fifth and not take the witness stand. The Sixth Amendment includes the right to a speedy trial by an impartial jury after an accused is charged with a crime. The accused also has a right to confront witnesses against them in a trial. So if the state charges you with a crime, this amendment says that you should get a trial, a speedy trial, meaning that soon after you're charged with a crime, you should be able to be tried by an impartial jury if you choose to have a jury trial. You also have the right to, if the state accuses you of a crime and they have information from witnesses, you have the right to confront those witnesses against you in a trial. The state cannot go to trial and say so-and-so said this about the defendant, the suspect. The person who did the talking or brought the information forward must be put on the witness stand, and you as the accused have a right to question that witness. The Eighth Amendment gives a person the right to bail and prevents excessive bail against an accused. So if you're arrested for a crime and you're brought to jail, you have a right to bail yourself out or have someone bail you. And each crime, depending on the seriousness of the crime, has a set amount of bail. If you're arrested for drunk driving, your bail would be less than if you were arrested for murder. In most states, there is no bail for murder. Let's say you were arrested for something, a lesser crime like burglary. There is a certain amount of bail for each type of crime. The 13th Amendment is also an important amendment. It outlawed slavery. Now this was, again, written in the 1800s, 18th century rather, back when slavery was legal in this country. And after the Civil War, this amendment was passed to make sure that this country would not be divided again because certain landowners chose to have slaves while others didn't. You got to remember that our ancestors also may have been slaves in Europe, whether they were black or white. Back in Europe, they were called serfs. They were made to work the land by rich landowners, and they worked for food on their table. As we moved into this country, slavery, this type of behavior was considered slavery, and it divided this country to the point where we had a civil war over it. And after the war, this amendment was put in there. The 14th Amendment states that any person shall not be deprived of life, liberty, or property without due process of law, nor deny any person equal protection of laws. This amendment refers to due process, which is if you're charged with a crime, you're going to have the ability to defend yourself in a court of law, and you're going to be treated equally. The rich will be treated the same as the poor. Some may argue that that's not the case today. The rich are able to hire expensive lawyers. They're more likely to get away with committing a crime than someone who does not have the ability to hire a lawyer or hires one that is not very experienced or as capable as the other lawyers with a good track history. Again, everybody is treated equally and is offered equal protection under our laws. Now, I mentioned earlier that our forefathers were very concerned with how this new government would run. They wrote a constitution, but they also developed what we call our government process today. They wanted the powers of the U.S. government to be divided into three branches so that they would not be ruled by a single entity, like a king, like they were back when they were in England. They wanted equal checks and balances amongst the three branches so that no single rule or a single group of people would govern them like they had been governed in England. Our forefathers devised a governing body to make our laws, and this governing body, as I stated earlier, would be divided into three parts. You have the legislative, the executive, and the judicial. Those three branches of the U.S. government are described as follows. The legislative branch, that's the branch that makes the laws. This is our Congress and our state legislatures throughout the land. When they feel that there's a need for a certain law, they will write the law up, they'll debate it, and then they'll take a vote on it as to whether the law will pass or not. Each legislature in each of our states, as well as our federal Congress, is divided into two houses. You have your House of Representatives and your Senate. And if a law is introduced by either house, it's debated, and that law must be passed by both houses in order for it to be law. The executive branch, that's the branch that enforces the laws. It includes the police, your local, state, federal police, and it also includes the President of the United States. Again, that's the branch that makes sure that when a law is passed, that law will be enforced. The third branch is what we call the judicial branch. This is the branch that interprets the laws. It includes your courts of law. It includes the Supreme Court, which reviews any appeals from the lower courts. Each law that is written may be interpreted differently by different people, and that's why we have a court system to deal with that. Our laws today go way back. Back before we moved to this country, in early times, ancient times, we had what we call common law. Common law is quite different than modern day law. Common law are laws that come from ancient times which everyone believed to be evil in themselves, such as the crime of murder or stealing. These laws were referred to in Latin terms as mala inse. Mala inse meaning evil in themselves. Now, before laws were written, everyone knew that it was evil to murder your neighbor. It was evil to steal your neighbor's crops, to steal your neighbor's livestock. It was evil to injure your neighbor, and so laws did not need to be written. It was common sense or common law that you should not be doing these things to your neighbor. As society progressed, we moved into an era of modern law where people needed to define laws or define them so that most people would know right from wrong. And we call these modern laws. These are laws that are more recent. These are laws that are passed by a legislative body prohibiting certain behaviors such as littering or dumping toxic waste. These laws are referred to in Latin terms as mala prohibita, meaning they're written to prohibit certain behaviors. And they are written by a legislative body as compared to a common law which was understood by most people. Common law did not have to be put in writing. Once laws were written by our legislature, we went a step further and we further defined the seriousness of laws. We wanted to define the seriousness of laws so that it would be apparent to everybody just how serious it is. Law books were written and crimes were classified as either felonies, misdemeanors, or civil infractions. They were divided into 3 categories. Felonies are crimes which are punishable by at least 1 year in jail. Such crimes as murder or rape, very serious crimes. And if you were convicted of this felony crime, you know that you could spend at least a year in jail, and in most cases much more, like in the crime of murder or rape. Misdemeanors are crimes which are punishable by less than a year in jail. Things like minor thefts or assault is a misdemeanor. Unless, of course, the assault is life-threatening. If you assault someone with a weapon or you injure them to the point where they could die from the assault, then that makes it a more serious crime, and that could be punishable by more than a year. Civil infractions are not referred to as crimes because they are less serious and are not punishable by any jail time. Examples of civil infractions are speeding tickets or other minor motor vehicle infractions. There are different classifications of crimes that I just mentioned. Most states will define crimes even further by classifying them in different classes according to the seriousness of the crime. Felonies are placed into Class A, B, or C categories in some states. Class A would be the most serious of the felonies. Class B would be less serious than A but more serious than C. Misdemeanors are also classed or placed into a class of either Class D or E categories. That being said, A felony Class A crime includes such crimes as manslaughter and rape. Class A crimes are punishable by at least 10 to 20 years in jail, whereas a Class B crime, which would include lesser crimes such as burglary and arson, Class B crimes are punishable by at least 5 to 10 years in jail. A felony Class C crime, which includes such crimes as aggravated assault, which I just explained to you. Aggravated assault would be an assault that's life-threatening. And another type of Class C crime would be criminal mischief. Class C crimes are punishable by at least 1 to 5 years in jail. Again, felonies are in most states are classified either Class A, Class B, Class C. The more serious types get the most jail time. Misdemeanor crimes such as drunk driving or driving without a license can also be punishable by up to 1 year in jail, but most misdemeanor crimes are punished by payment of a fine. So where felonies are A, B, or C, misdemeanor crimes are classified as D or E. And they're punishable by less than a year in jail. Now, civil infractions, those are the lesser of all crimes. They are only punishable by a monetary fine. In order to have a crime committed, you must, of course, have a law that's been passed prohibiting certain behavior. Having 3 branches of government makes it extremely difficult to pass laws. The legislative branch passes the laws, but often it is done with great difficulty because the legislature is made up of 2 houses, the House of Representatives and the Senate. A law has to have the approval of both houses before it passes. The law then goes before the president or state governor. If the president or a governor of a state vetoes the law, then it goes back to the legislature. A veto can only be overturned by a 2/3 vote of Congress or a state legislature. So even though a law was passed by the legislature, if the governor or a president vetoes that law, it doesn't become law until the legislature or Congress can overturn that law by having a 2/3 vote in favor of the law. So if a law passes the legislature, let's say 51% to 49%, 51% being in favor, they pass a law. If a governor or a president refuses to sign the law by a veto, then that law does not have much chance of being passed if it goes back to the legislature. It narrowly passed to begin with, and unless they can come up with a 2/3 vote, meaning 67% to 33%, 67 being 2/3, at least 2/3 vote in favor, then that law does not go into effect. Even if a law is passed, the Supreme Court could rule it unconstitutional, or law enforcement could simply refuse to enforce it. Now you may think, well, if a law is unconstitutional, then that's the Supreme Court is the law of the land, so that law is no longer in effect. But what about law enforcement as far as refusing to enforce a law? Well, let me give you an example. Most towns have what we call curfew laws, meaning that teenagers, let's say people under the age of 18, have to be off the streets by a certain time. And those types of laws, curfew laws, aren't always enforced, and they're not always enforced equally. Police are usually very busy. If they see a 16-year-old on a sidewalk they recognize to be 16, they may choose not to do anything about a 16-year-old walking around after curfew, especially if that teenager is not a troublemaker. Or the police may simply be too busy that night to take this teenager home and charge him with a curfew law. Most states, another example, most states have a seatbelt law. Everyone under the age of 18 must wear a seatbelt. There are times where police will not take the time to enforce that law, especially if they're busy or they don't have a right, excuse me, have a right to stop a vehicle, or they may choose to not enforce it because they don't think it's an important law. Some laws, such as the Brady Bill, which is a gun law, sometimes the law has a long, hard road that may take years for that law to pass. Let me give you an example of the Brady Bill law. The Brady Bill law came out as a result of John W. Hinckley Jr. In his attempt to assassinate President Ronald Reagan on March 30 of 1981. James Brady was Ronald Reagan's press secretary, and he was at his side the day that President Reagan was shot, and James Brady took a shot to the head, leaving him permanently disabled. 7 years later, an attempt would be made to limit the sale of firearms to private citizens. So the assassination took place on March 30, 1981. On June 30, 1988, in the House of Representatives, an amendment was added to a drug enforcement bill calling for a 7-day waiting period in the sale of pistols before a purchaser would be given the gun. This would allow time for police officers to check the purchaser's background. You know, John Hinckley Jr. had mental problems, and most felt that he should not have been able to have a firearm. Mental problems meaning he suffered from psychological problems. The average American citizen believed that, you know, if you suffer from psychological problems, you should not have a firearm, or if you have a criminal record, you should not have a firearm. So this amendment to this drug enforcement bill, the amendment that was added to it was called the Brady Amendment for James Brady. On July 6, 1988, President Reagan, who was a longtime opponent of gun controls and a member of the National Rifle Association, he comes out in favor of this 7-day waiting period. Even though he's what we call a gun nut, loves guns, he was in favor of it. The Law Enforcement Steering Committee, which is a national police organization, lent its support of this bill, calling for this waiting period. Now, a couple months later, the Brady bill would be argued many times. It was finally passed in 1988, but the NRA stepped in and argued on behalf of everyone who owned a gun and wanted to purchase more guns under the Right to Bear Arms Amendment. Although the bill passed one house, it did not pass the other house because the NRA really fought against it. After the bill was introduced in 1988, it took another 5 years for the law to pass. Many presidents, President Bush and his son, would be president before the bill was finally passed and signed by President Clinton in 1993. Like most laws, even if they are signed by a president or a governor, they will not go into effect until a 90-day waiting period. This Brady bill, or Brady law, which requires a 7-day waiting period when you buy a firearm, it finally went into effect on February 28, 1994, 13 years after President Ronald Reagan was shot. This concludes this lecture. Have a good day, class.